if the committee members could please turn on their cameras, and Attorney Del Campo, if you can take a roll call and indicate whether a quorum is present.
Yes, Your Honor. Justice Alexander is here. Judge Aaron?
Here.
Judge Armada?
Here.
Judge Chaplin?
Here.
Judge Green?
Here.
Judge McLaughlin?
Here.
Judge Pearson?
Judge Pearson's here. Sorry.
Thank you. Judge Stewart? I think you're muted, Judge Stewart.
Here, sorry.
That's okay. Judge Maturowski?
Here.
We have a quorum, Your Honor.
Thank you. So the first item on our agenda is the approval of the minutes from the February 10th, 2025 meeting. Is there a motion to approve the minutes?
So moved.
Is there a second?
So I will second.
Thank you, Judge Pearson. Are there any additions or changes to the minutes?
Your Honor, yes, on page 2, paragraph 3, second sentence, it should start by saying working group. It should say put together a working group to draft A. A and draft are transposed. So we've just flipped those words and we should be all set.
Right. Thank you. Any other additions or changes by the committee members? All right, I don't hear any, so all in favor of the minutes, say aye or raise your hand.
Aye.
Good.
Aye.
Anyone opposed? And is there anyone who is abstaining from those minutes? Just state your name.
Judge Maturowski, I'll abstain as I was not present.
Perfect. So the minutes are approved, and without further ado, then we are going to go over to our agenda items. The first item is 2025-005, which is a proposal to amend section 277 concerning the amount from the client security fund to be paid in a calendar year. And Attorney Del Campo, if you could just summarize this for us briefly.
Yes, that's brand new, Your Honor. The first time being considered. That was submitted by Judge Bizzuto. She is here today. That's basically to permit up to 25% of the amount received by the Client Security Fund to pay for lawyers' assistance programs. It's currently up to 15.9%. This change would allow the increase to take, that would be a maximum, and it will not increase the costs to attorneys. I believe it's still going to stay at the $75 level.
All right. With respect to it, I do see Judge Bizzuto here. Did you want to be heard on this proposal or anyone else? But I'll start with you.
Thank you, Justice Alexander. It's good to see you. Thank you for giving me just a few minutes, just briefly to go over this. I mean, Joe, thanks for the intro. You did a perfect job in summarizing it. I used to be on the Assistance Advisory Committee for the organization that provides this sort of assistance to lawyers as well as judges who are in crisis, and kind of knew nothing about it. So let me just if I can just take 2 minutes to step back to give people some context. So statutorily, the Client Security Fund was established some time ago, and it really addresses 3 identified needs, some of which we know clearly. When a lawyer defalcates or is dishonest, and that conduct causes some harm to a litigant, this fund is used to reimburse them to make them whole. There's also grant and aid, which is number 2, to an organization, a legal aid provider. And then the third one is that the Client Security Fund is to provide crisis intervention and referral assistance for lawyers suffering from addiction or mental health. So that's their third, the third prong of what this fund is used. It's the $75 per year, which we all pay. There'll be no impact on that. But since 2005, the percentage that has been devoted to crisis intervention services has been at 15.9%. And the branch contracts with the provider. It's a 3-year contract that is goes out by way of RFP. It's a competitive process there is an opportunity for a 2-year extension. And that is coming due actually July of 2025. So there'll be a new contract, we'll have a new RPF. But the Attorney Assistant Advisory Committee that's required for the Chief Court Administrator to maintain meets with the current provider regularly. And that's Lawyers Concerned for Lawyers. I forget how often the meetings they are. They may be quarterly. And on that committee are a number of judges, as well as lawyers and mental health professionals. But we also have joining our meeting, the membership, the board, and the executives from Lawyers Concerned for Lawyers. And they have put on our radar for some time now that the increase in pressure on Lawyers Concerned for Lawyers, as far as providing mental health services to lawyers and judges, has increased exponentially. It now outpaces what they provide for substance abuse and alcohol addiction. So that's been on a steady increase. And that not only requires more resources, but now we have only one executive director who runs the whole organization. And we're lucky, it's Dave Williams. He's the executive director, has been there for some time. The branch has gotten, a tremendous savings from this particular organization being the successful bidder because Dave Williams is a former branch employee. So all he gets is a salary. There's no pressure on medical insurance or pension or anything like that. He's due to retire, so that's going to be changed and will be addressed in the new RFP. But they need an additional staff member in addition to the one executive director. And there was some concern raised at one of the meetings regarding the client security fund itself, because it did take a little bit of a dip in 2022 and 2023, and maybe rebounding in 2024. But that has a direct impact on the crisis service intervention, because of course, 15.9% of a lesser amount is a smaller budget. So the advisory committee took this under consideration, has proposed and approved the increase to up to 25%, has submitted for my consideration as well, and also to the Client Security Fund Committee itself, who's chaired by Judge Mall, and they have approved this change, the practice book, from 15.9% up to 25%, as may be when we go out to bid again in July, to provide that additional cushion for additional expenses, which we are anticipating. So that's kind of a summary of what this particular fund does, and the basis for the request from 15.9% up to 25%. I'm not the only one on. I know Judge Facito's on as well. She sits on the advisory committee. I'm not sure if Judge Rohraback is on, but he is the chair of the advisory committee who meets regularly with the Lawyers Concerned for Lawyer. And I also see Attorney Bill Sweeney. I think he might be chairman of the board. Attorney Sweeney, if I got that right, of the Lawyers Concerned for Lawyers. You're on mute, so I'm not sure if they have any more to add or whether there's any questions that anyone on the Rules Committee might have.
Well, we'll start with Judge Facito or Judge Rohraback. I'm not sure you're here. Would either of you like to add anything to what Judge Bizzuto has said?
So I am here, Justice Alexander, but I think it's all been very clearly summarized. Thank you.
All right. And I'm not sure if Judge Rohraback is on. Attorney Del Campo, do you see him?
I do not see him, Your Honor.
Okay. And Attorney Sweeney, you have unmuted yourself, so I would invite you if you have any further comments in addition to what Judge Bizzuto has said.
Thank you, Justice Alexander. I learned a long time ago to stop talking when you're ahead of the game, so I'm going to stop talking because Judge Bizzuto has summed it up as well as anybody could, and would certainly urge that the committee accept her recommendation.
All right. Thank you so much. Do any of our committee members have questions for Judge Bizzuto or Judge Facito or Attorney Sweeney? I don't see any. So this is obviously very time sensitive because, as Judge Bizzuto's indicated, it's coming up for renewal in July. I think that their committee's consideration has been very thoughtful. It is not changing the fee that anyone pays into the client security fund, but it is addressing a very important need. I've also been assured that it is well funded for any type of payment that might be necessary if an attorney were to defraud a client. That is very well funded, the whole situation. So I would ask this committee if you are willing to move this to us and send it to the public hearing in May so that we can make these important changes in an expeditious manner.
Justice Alexander, I'm more than happy to move this item to a committee vote.
All right. And
Judge Pearson.
Thank you.
I would
Is there a
second
second? Okay.
that. I would
and
second that.
I think that was Judge
Aaron.
Stewart. Aaron, okay, thank you. Is there any further discussion? Seeing none, all in favor, either raise your hand or say aye.
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 Any opposed? No, and it passes unanimously. And Attorney Del Campo, if I didn't add what I was supposed to, I think this is one that we would need to actually ask for a special marking so that it could take effect sooner rather than our ordinary rule date. Is that correct?
Yes, Your Honor. If you ultimately recommend it to the judges and they adopt it, you would make the recommendation that it be adopted on an expedited basis, which means that they would waive the provision of the practice book, section 1-9, that talks about rules not being effective until at least 60 days after promulgation, which is publication in the Law Journal. You could actually, if you do that and the judges accept that, then it could be effective basically when it's published in the Law Journal. So it's early July, likely.
Very good. All right. Thank you. And thank you, Judge Pizzuto, for presenting that to us.
Thank
Our
you.
next-
Thank you to the committee.
Yes, Judge Alexander, this is Judge
Yes.
Chaplin. Just want to note for the record that I am abstaining from that vote as I am a current board member for Lawyers Concerned for Lawyers.
Okay. Noted. Thank you. Our next matter is 2025-006, which is the amendment to section 227, a large A, concerning minimum continuing legal education to allow a portion of the hours to be satisfied by providing pro bono services. And Attorney Del Campo, if you could give us a little background on this, please.
Yes, Your Honor. This also is first time being considered. It was also submitted by Judge Pizzuto. Basically, it would allow attorneys to fulfill the requirement for MCLE by providing pro bono legal services at the rate of 1 hour for every 2 hours that they perform the service, up to a maximum of 6 hours per year. And again, there are some restrictions on it. Again, I think Judge Pizzuto is here and can speak to that. And I believe Attorney Rowe is here as well.
All right. I'm not sure if Judge Pizzuto is available. Oh, she might be. So if you'd like to address us on the MCLEs.
Thank you. I'm sorry about that. And Attorney Del Campo did another great job summarizing the request. This one we're all familiar with. It's going to be much shorter for me to introduce than the last one. But as you know, we all have to do, or lawyers have to do 12 hours of continuing legal ed each year on the honor system. This would amend that so that up to 6 of those 12 hours may be satisfied by providing pro bono services at the rate of 2 hours of pro bono service for every 1 credit of continuing legal ed. It was before the committee, Committee on Continuing Legal Ed. They voted on it and approved this change. It was a split vote, a 6-2 vote, but nonetheless, it passed out of there. I know that Judge Bright, who is chair of the Access to Justice Commission, his committee was looking at this. He, of course, is in favor of this. If anyone watched his appointment hearing, He let the judiciary know that he was very much in favor of amending the practice book rule to allow for some pro bono work to satisfy the continuing legal ed requirements. And I know the CBA also is working on a separate proposal. If this one does, if you see fit to pass this one, I think that's going to satisfy the CBA. I think their proposal provided for the requirement to do more hours pro bono. And what we actually did was we looked at neighboring states. New York State, for example, does 2 hours pro bono for 1 hour of MCLE credits. We looked at Massachusetts. Massachusetts still does not even require minimum continuing legal education. So, you know, with respect to our neighboring states, this is similar exactly what New York has done, and we would ask for your thoughtful consideration in approving this request. And I'm happy to answer any questions anyone may have. And again, just so happens that Judge Facito's also on the screen. She is a member of the Minimum Continuing Legal Ed Committee, was present for that vote. I'm not sure if she has additional insights to offer with respect to their consideration.
Judge Facito?
Once again, Judge Bizzuto's summary was very thoughtful and complete. I will only add as well that there is legislative support for this proposal as well as the CBA. Thank you.
All right, thank you. And is there anyone here who wishes to comment also? You said Attorney Rowe may have participated?
Hello, this is Melissa Biggs. I work with the CBA. I know that we are looking at our own separate proposal. I have not received feedback on whether they'd be supportive of the current MCLE proposal, only that we would like the opportunity to look at it and submit comments.
And would you have any objection to those comments being made for the public hearing?
I do
If
not
we
think
move
so.
this, okay, thank you. And I see Attorney Rowe, you're on the screen now. Thank you.
Yes, Your Honor. I'm the counsel to the Minimum Continuing Legal Education Commission. They did meet, they support the proposal. We did look at all 50 states. About half of states allow this as a CLE option. And our proposal is within, it's generous, but is within the guidelines of what other states are doing. And one restriction we also had suggested, which is similar to New York, is that the pro bono must be done in the state of Connecticut, which would meet what the interests of the judicial branch as well as the legislature, that this would assist Connecticut residents.
Thank you. Thank you for those comments. Do any committee members have questions for either Judge Pizzuto, Judge Facito, Attorney Rowe? Any questions for these members? Any further questions? All right, seeing none. Again, I know that these are coming in quickly, but it's important. It's something that I know that there's been a lot of discussion about making these requirements of MCLE, and this seems consistent with the goals that we had in establishing this type of program. So if there's no further questions or comments, is there any objection? And obviously, Attorney Biggs said the CBA may in fact comment at the public hearing, but is there any objection to moving this over to the public hearing on May 5th? And if not, I'd ask for a motion by one of our committee members.
I would move to amend section 2-27A to add subsection 8 to allow for uncompensated legal services for clients unable to afford counsel under the supervision of an organized legal aid society, state or local bar association project, or a court-affiliated pro bono program in Connecticut, and to adopt that amendment.
Right?
I'll
Is
second
there
the
a-
motion.
All right, and that's Judge Pearson. It's been moved and seconded. Any discussion?
Justice Alexander,
Yes.
I'd like to add a friendly amendment to that we also consider the new section 4 that had been put in to credit uncompensated legal services provider pursuant to section 8B above, so that we're consistent with the proposal.
Yeah, that's excellent. Very good.
Thank you.
All right, any further discussion? All right, it's been moved and seconded, so all in favor, say aye or raise your hand.
Aye.
All right, any opposed? All right, this passes unanimously and it will be put on for the public hearing on May 5th. And Attorney Biggs, I would say that if you wanted to send in a comment earlier, just like we do on these meetings, that the CBA is more than welcome to send their comment in before if they'd prefer not to appear at the hearing.
Thank you very much.
Okay,
Thank
Our
you, Justice
next-
Alexander, members of the committee. Thank you very much.
thanks Judge Pizzuto and Judge Faceto. Let's see, our next is 2025-001, which is the proposal to amend practice book section 1035 concerning the request to revise. And Attorney Del Campo, if you can give us a brief update on this.
Yes, Your Honor. This was previously on the agenda in January. It was moved to this agenda. You asked that Judge Diana be notified of this. It came through originally on behalf of Representative Staffstrom after having talked with Judge Bella. So you sent it to Judge Diana. He supports the proposal. We also sent it to the CBA and the CTLA. Neither of those organizations had any comments. I mean, they replied, but they had no comments on the proposal. That is the status of it at this point.
Right, is there anyone here to address the committee on this matter? Is there anyone here? Right, and I don't see anyone. Are there any questions by the committee for Attorney Del Campo? No? All right, then with respect to it, again, this was something that Judge Bellis brought to our attention. It is going to assist in their pleadings to have at times the contract be attached to a request to revise. So if there are no other questions or comments, I would ask that this be sent to the public hearing for May 5th. And would any committee member like to make that motion?
I'll make the motion, Judge Pearson.
Thank you. Is there a second?
Second.
All right, and that's Judge Chaplin. Any discussion by the committee?
Can I just ask a question?
Of course.
I'm just, when I read it, there's something about the language that doesn't read, unless I'm reading it incorrectly. It just seems awkward when I read, whenever any party desires to obtain, and then it goes 1, 2, 3, or attachment to adverse parties complaint. I just think the language, it needs
Just
some
tweaking from
tweaking
obtain
of the
to
language.
attach. Okay, you're not objecting to the concept.
I'm not objecting to it at
okay.
all. I just the languaging of it.
Well, I'm hoping that Judge Pearson with his hand up can give us the magic language that we need.
How about Judge Aaron, how about an attachment? I agree with you, it's a little awkward.
Thank you.
Just adding the word an
attachment.
or the word attachment. It's still not the most beautiful English there is, but I think it gets the idea across sufficiently.
Fair enough. Thank you.
I'm open for other wordsmithing that's out there. So right now we're moving it to change to and attachment, but if someone comes up with yet a better refinement, it's always welcome, and we will make that our final draft for the public hearing. So good point. Is there a second to, did I already do a second? I can't remember. Yes, all right. So that was the discussion. So all in favor of sending this proposal to our public hearing? Aye. Got a lot of hands
Aye.
up. Any opposed? None. So it passes unanimously, and we'll go over to our public hearing. All right, the next matter we have is 2023-11. And with respect to this is the requirement that attorneys who use AI programs to conduct legal research, append a certification, etc. I think I'm going to short circuit this and not send it to Attorney Del Campo for discussion. We're still working on our final recommendations in the AI committee. Judge Armada's on that committee with me. And I think we are going to look to create a subcommittee to kind of analyze this. It's quite an ambitious project, and it changes probably every day. We're behind in times. So my proposal, unless there's objection by the committee, is to move this over to the fall. We will probably be reaching out to you between the AI committee and the rules committee to see what we can do to put this together and help the judicial branch and our rules address AI. If anyone wants further discussion before we move on to the next matter, I'm all ears.
Justice Alexander,
Sure.
I'm lucky enough to be on the branch's AI committee, and the committee is doing great work, and we're getting a lot of information. And at the last meeting, we had an incredible presentation by Claudia Jilwalka about this. But there seems to be different philosophies among the different states. Some courts are just acknowledging that AI exists. Others are requiring certification, and then there's groups in between. And I think we've got to understand what those states are doing and have a subcommittee look to make recommendations to this committee of which camp do we want to fall into. And as Justice Alexander said, it is changing minute by minute as new technologies, new devices, and it's being built into applications that we all touch and without even using it. So, you know, we'll probably draw people from this committee and the other committee to sort of have a philosophical discussion about where we want to be and what we want to recommend.
And I think Judge Armada is definitely talking himself into that subcommittee on both panels. So is there any other discussion or questions? I'll say for Judge Armada at this point. All right.
This is Judge Stewart. I will be, I believe, off this committee by the fall because I think I'm term limited. But I just would suggest a word of caution. I think Judge Armada has accurately characterized that there's two camps here, but I do still, as a former managing partner of a firm, receive an awful lot of law firm management correspondence and so on. And I think it would be a mistake to have a rule that's solely focused on people's legal research using AI. Because, for example, one of the things I read recently was that 40% of the AmLaw 200, some of which practices in our court, has their own in-house AI. Not to mention that even before I left practice, essentially we were using AI to do our discovery. So it seems sort of silly to me, honestly, to be certifying just about your legal research, or worse yet, to be saying, no, we didn't use AI, when in fact you're using AI for all sorts of other functions that might have led to the filing. So I think you all need to tread very carefully if you try to change the rules with respect to AI, particularly since things are developing so quickly.
Thank you. Thank you for the comments. I will miss you on the rules committee, but we could still somehow manage to get you on a subcommittee, I bet.
I don't know about that.
All right. Any other comments or discussion? And I think this also encompasses, am I correct, Attorney Del Campo, 2023-14, correct?
Yes, that's correct, Your Honor, yes.
Okay, so we'll move both of those agenda items over to the fall. Our next item on today's agenda is 2024-14, which is a proposal to amend practice book sections 1326 et al. To reflect the adoption of the Interstate Depositions and Discovery Act in Connecticut. And I think this was Judge Stewart, you had spearheaded some of this. And I know also that Lori Petrozelli from our legal office has worked on this extensively. So perhaps I should ask Attorney Del Campo where we are on this and then open it up for further comment.
Yes, Your Honor, this was previously on for January. Judge Stewart and the subcommittee did work on it, presented the subcommittee's proposal, and simply asked that we make it practice book ready. So what you have here is a clean, an absolutely clean version, which is how it would look, presuming you adopted everything that was in the subcommittee's proposal. And the other one is the red line version, which basically shows the underlines and the brackets and how it looks, or how it's been amended from what currently is the practice book. So I'm sure Judge Stewart will explain the merits of it.
Go ahead.
I don't have much to add other than to say, since the last version, this I think is the third or fourth time this has been in front of the full committee, but since the last version, the only changes that were made were, first of all, to add commentary to each one of the proposed rules. Second of all, to pick up on the fact that CTLA brought to our attention that we were using the 2024 version of the rule as opposed to 2025 version of Rule 1329. So there have been some unrelated amendments that the committee passed last year. So I made sure that those are now incorporated in here. And then at our last meeting, the sense of the committee was to add two things, and those are at 13-28A subsection G. It alerts people who are parties that they can, of course, use the protective order device and directs them to the appropriate rule for that. And 13-28I, the old rule, provided basically if you weren't complying with a subpoena, that essentially you could be sent to jail for that. And we thought collectively that that was a bit harsh to be the only option. So we also refer in there to Rule 13-14, which is the discovery sanctions rule that gives people, judges rather, a few more options than holding people in contempt and sending them off. So that's really all we've done since the last time the committee saw the rules. And Attorney Petrozelli did a formal red line of everything.
Great, thank you. Is there anyone else here who would like to address the committee members before I open it up for questions? And again, Attorney Petrozelli, thank you for all your work on this. It was an extraordinary.
Thank you, Your Honor.
With respect to this, then, are there any questions from the committee to either Judge Stewart or Attorney Petrozelli? I'm going to put myself outside of those questions. Seeing none, I would accept the motion to send this to the public hearing as, I guess, written now. Finally, we have it written exactly the way we want it. Is there any judge making that motion?
So moved.
Thank you. Second.
Second.
Any discussion? Hearing none. All in favor, say aye.
Aye.
Any opposed? All right, it passes unanimously and will be placed on the public hearing. Thank you, Judge Stewart, also for all your work on this. You can come
And
back.
thank you to my subcommittee.
We can waive the time requirements on rules members. I don't see any approval on that. All right, our next matter is 2024-16, which is also related to 2024-20. And that was, the 16 was proposed after a subcommittee consisting of Judge Chaplin, Judge Pearson, and Judge Green. Unfortunately, we got information, I think today, that Troy Brown was not able to attend, who is the branch's DEI director. Attorney Del Campo, again, I don't mean to go in front of your usual bringing up to speed to us. One of the things we had discussed, obviously, was that this proposal has been vetted, but it will apply to multiple areas potentially in the practice book, and we want to make sure that if it goes if it goes out to public hearing, that we have managed to find the association between this proposal and anywhere else that it may need reference back to in our rules. So I had asked Attorney Del Campo and his staff to start looking in the practice book to other areas that we may need to consider a similar change. So with respect to this, I would propose that it go over to the fall, even though we have the language that we need, just to make sure that we're not overlooking anything in the practice book right now. And I know Attorney Steele sometimes comes to these meetings because she proposed the one under 20. And obviously that would also be rather extensive. Does anyone want discussion on this, or are you all right with it going to the fall, just for our legal staff to look at and make sure that we're not overlooking any other area in the practice book?
Judge Pearson has his hand up.
Oh, good. Okay.
So Justice Alexander, I don't have any comment to make about, acting on it now versus the fall. Because what you're proposing makes a lot of sense, making sure that there's harmony between these proposed provisions and the rest of the practice book. I did want to bring to Attorney Del Campo's attention, however, I did find a technical error in the subcommittee's proposed language. And that is the commentary to section 3.3C, subsection C. Commentary to subsection C of practice book, section 3-3. Within the body of that commentary, there are two references to subsection B. That's incorrect. It should say subsection C in both instances. And I just wanted to bring that technical error to your attention.
Thank you, Your Honor.
Thank you.
Oh, thank you. And thank you again for your work. Is there any other questions or comments? And again, I'm not trying to, cut off questions or commentary, but I do, having had this minimal experience my first year, it seems that a lot of times we go backwards to then change something that should have been moved with the rule, and because of the breadth of this, I want to make sure that we have it correct. All right, so that will be marked over to the fall. Our next matter then on the agenda is 2024-17, which is the request to amend the practice book concerning certified legal interns. And that was brought to us by Attorney Cicchetti, who is the chief clerk at the appellate court. With respect to it, Attorney Del Campo, I think we have now received commentary from all the law school deans that we sent out to.
Yes, Your Honor.
And they all agree with it?
Yes, they do.
All right. And is there any other update as to this that the committee should know?
Well, just to make certain that I failed to give you the actual revised proposal, which was originally suggested by Dean Nelson, and picked up on by Judge Stewart and recommended by Judge Stewart. I did send that to you later, earlier this morning or this afternoon. It's the proposal that basically amends 316 by deleting subdivision 5 and repeals totally section 3-21.
Okay. Is there anyone here to address the committee on this matter? Right. I can see your face, Attorney Cicchetti, but I don't think there's any further comment that you need to make. Is that correct?
That's correct, Your Honor. You and Attorney Del Campo summed it up perfectly, so I appreciate that.
All right. If there are no other questions or comments, then I would accept a motion to approve sending this to the public hearing, subject to the changes. Okay. So that was Judge Armada. A second?
Second, Judge Aaron.
Judge Aaron. And any discussion?
Your Honor, or Joe, just this is just a technical comment, and I don't know if it's on point or not, but should there be an and after 3 and before 4 and then a period at the end of 4?
Well, yeah, probably.
Like I said, it was hyper technical, but for drafting.
I'm used to hyper technical, trust me. That's very well taken. Thank you.
We're talking about 3-16 after 3 and before 4.
Correct.
There is not now a and after 4 and before 5. So I don't know if that changes the meaning of this or not. That would be a new word added in. It's not there now. I know Lori is actually very astute with these things. She may want to chime in, Attorney Petrozelli, but I'm just pointing out to the committee that and is not there presently in that series. And if you put it in, I don't know if it has the effect of changing the interpretation of that.
What say you, Attorney Petrozelli?
I think usually we defer to the reporter of judicial decisions for those type of changes, but I would agree with Becky that usually we do add some sort of conjunction at the final semicolon before the next numbered one. It would either have an or if they're in the disjunctive, or an and if they're in the conjunctive, followed by the period. So
we have an and a period. Is that what you're proposing?
Yes. Yes.
All right. Judge Chaplin, your hand is up. Would you like a semicolon with that?
No, I'll just note that Dean Nelson raised that concern earlier in some of the materials submitted by Attorney Del Campo, and I thought we discussed that at that time. I just wanted to bring that to our recollection.
All right. So subject to the, I would call it a minor amendment. Technical, I think was the term used. We'll add the and, put in the period, and we will send it to the public hearing. And I think I took the vote, but I'm taking so many votes and this and that, have we taken the vote on this one?
Yes, you're
all in favor? Aye. Any opposed? None. Sent to public hearing for May 5th. Thank you. 2020 was with the discussion on 16. Our next one is 2024-21, which is a proposal to amend practice book section 1014 for proof of service to comport with the newly amended 1013 method. I think this was brought to our attention by Judge Bellis. It's a pretty straightforward, and I think it then amends the practice book forms also. Is that correct, Joe?
Yes, Your Honor. We added to the proposal the associated amendments to practice book forms, to the forms that are in the back of the practice book. Attorney Petrozelli made those amendments. It changes the certification in every one of those forms to be compliant with this rule change.
All right. Is there anyone here to address the committee on this? I don't think Judge Bellis is here today. Are there any questions from the committee about this proposal? And I think we have received all the commentary from the different administrative judges, correct?
Yes, Your Honor.
All right. So if there are no other comments or questions, I would accept a motion to approve sending this to the public hearing.
So moved.
Okay, that's
Second.
all right. Any questions, any discussion? Hearing none, all in favor, say aye or raise your hand. Any opposed? Passes unanimously and will be on the public hearing agenda. And we have 2025-002, which is the proposal to repeal practice book section 1612 and to add a new rule, section 15.9, that provides for a procedure that allows for a view of a place or thing involved in a case. Again, this was submitted to us by Judge Bellis. And Attorney Del Campo, can you update us on the history?
Yes, Your Honor. Again, last on the agenda, February, we did send it out to the CBA. We did receive comments today, actually. They have no comments on the proposal. And that's the status at this point, Your Honor.
Great. Is there anyone here to address the committee on this matter? And does anyone have any questions? I reluctantly say for myself or Attorney Del Campo, but go ahead.
I'm just wondering, has this been sent to CTLA and the defense bar for comment?
That would be a Attorney Del Campo
No,
question.
no, Your Honor, it has not. I think you decided last time to send it to the CBA only. I don't know that you excluded the others, but you had me send it to the CBA.
I just wonder if it perhaps should be sent to them for comment as well.
I agree with Judge Aaron. I think that you would get more of a response from those two organizations.
Justice
And
Alexander.
Hi, Attorney Dowd.
Hi, Carolina Dowd. I'm here from CTLA, and I welcome the comments from the judges. I think that this is something that would be very relevant to our practice, and I don't believe that we were provided a copy of the proposal, so we definitely would welcome the opportunity to review it.
Right. Well, that informs this decision where it's going. So we're going to send it to CTLA. Who else did you recommend, Judge Aaron?
The defense bar?
So, okay.
Yeah, it's
And
CDA.
CD, okay. Right. And
Good afternoon, Your Honor. This is Attorney. Apologies, Your Honor. Attorney Robert Salerno. From the CCDLA, I am the liaison for the Northwest Corner. I'd be happy to provide that to the president of the CCDLA at this time if you would like to send it over.
that would be excellent. Thank you for speaking up. It's so hard on these screens to see who's here. So we will certainly send it to you as well as any other. Again, Judge Aaron, Judge Stewart, Judge Pearson, you have any other areas you think we should, any other organizations we should send it to? No? Okay. So this will go over to, unfortunately, the fall for commentary because I don't think it will be ready in time for the public hearing.
Your Honor, can I ask, I just want to clarify, CTLA, CCDLA, and did you say CDLA?
I was using an old acronym. He's correct.
Okay.
Perfect. Thank you. Our next matter, so this is over to the fall.
To the fall, okay.
Our next matter is 2025-007, a proposal by Assistant Reporter of Judicial Decisions to revise 717. Attorney Del Campo.
Yes, Your Honor, that actually is it's technical in the sense of what it's doing. There are some arcane language that the reporter's office would like to remove from the practice book. I thought it best to get it before the committee because it actually is a change to the rule. It's not just a correction of a typo or something like that. So they're changing, I believe, putting in
Forenoon.
AM. Yes.
Instead of
AM.
forenoon and afternoon, it's now AM and PM.
Yes.
It's, okay. Do we need to send this out for a comment?
No.
Or? Okay.
No, Your Honor.
You never know.
You
with
need a
this committee.
subcommittee on it?
I think
Yes,
there
Your
should be a subcommittee. Maybe the AI can look into this. With that, is there anyone here to address the committee on this matter besides Attorney Del Campo?
Joe,
I move that
Andrew Redmond is online. You may want to, from the reporter's office.
Oh, okay.
Yes, Attorney Redmond is here.
Thank you.
Thank you, Your Honors. I have nothing to add. Joe explained it as succinctly and accurately as possible.
All right. With respect to that, does anyone have any questions for Attorney Redmond or Attorney Del Campo? I'm not taking any more questions on this myself. No questions, then again, I think that this is straightforward and can go right to the public hearing. So I would accept a motion to approve sending this to the public hearing.
So moved.
Green.
Okay, and second.
I'll second Armada.
Thank you. Discussion? Hearing none. All in favor, raise your hand or say aye. Any opposed? Approved unanimously and sent to public hearing. And with respect to 2025-008, and that is a proposal to amend practice book section 215 large A to correct a reference to a subsection in the rule. Attorney Del Campo.
Yes, Your Honor, this is first time being considered. It's exactly what you said. It's the Connecticut Bar Examining Committee noticed that one of the references in the practice book wasn't updated when there was a change made, and they would just like to update that reference citation.
Right, is there anyone here to address the committee on this matter?
I believe Attorney Valco is here if she would like to address it.
Hi, thank you. I have nothing to add. You described it perfectly, Attorney Del Campo. Thank you.
Any questions for Attorney Del Campo or Attorney Valco? Hearing none, if there's no other questions or comment, I'll accept the motion to approve sending this to the public hearing for the changes as noted.
So moved.
A second?
Second.
Second.
All right, any discussion? All in favor, raise your hand or say aye. Any opposed? None. Passes unanimously and will be sent to our public hearing, which is on May 5th at 10 a.m. and it will take place in the Supreme Court courtroom. Is that correct, Attorney Del Campo?
Yes, Your Honor.
So I will not look as confused. I'll still be confused, but I'll be able to see everyone, which makes it a lot easier if you're trying to chair a committee to be able to see all of you. And again, I want to thank you for all the work you put in on this committee. There's a lot of material to review, and I can't thank each of you enough for participating and all of your insight and knowledge and comments are appreciated. So I'll say it again in May, but thank you online for YouTube purposes for your great work. So with that, I would make a motion to adjourn today's meeting unless there's something else anyone needs to discuss.
Your Honor,
Justice sorry,
go
Justice Alexander, I'd like to make a motion to adjourn, but subject to Attorney Del Campo, who has his hand up.
Okay, we'll give. Did I miss something, Joe?
No, no, you did not. I just wanted to note for the committee's information that when you put matters to public hearing, and certainly when they go to the judges, they always have commentaries attached. There are a few proposals that have gone through now that don't have commentaries, so I will draft informational commentaries to those. You'll have a chance if you'd like to modify them, when you see them for the public hearing, but just so that you haven't yet seen them, but they will show up in the materials for the public hearing so that they're complete. And then if you'd like to modify them, you could just let me know that at the meeting after the public hearing.
All right, thank you. So now can I move to adjourn?
Yes,
Or
so
ask
moved.
someone to move? Okay.
Second.
Second.
All right. Meeting is adjourned. Thank you all again. Have a good
Thank
day. We'll
you.
see you in May. Bye-bye.
Take care.